Hi everyone and welcome to another episode. Today I want to discuss a topic that is very important to consider when passing laws, especially passing controversial laws. Laws like the laws related to abortion, laws related to prostitution, surrogacy, euthanasia, laws pertaining to the LGBTQ communities. When passing these kinds of laws, what should the lawmaker give effect to more? Should they consider the individual freedoms of society more, or should they give effect to the common morality of that society? Let's discuss. The most prominent discussion on this topic arose between Professor H.L.A. Hart and Justice Devlin. The catalyst for this debate was the publishing of the Wolfenden Report in 1957. Now, in the United Kingdom, a committee of 15 people led by Sir Wolfenden were appointed in the early 1950s to consider whether homosexuality needed to be criminalized or decriminalized in that society. Having considered a lot of facts, having heard a lot of evidence, the committee reported back that homosexuality should not be criminalized. They recognized that there was a realm of private life that should not be the concern of the law. And that is what's important. They considered that there was a realm of private life that should not be the consideration of the law. Now, this idea that there was an element of private life that should not be the business of law was opposed to by Lord Devlin in 1957. He believed that the law's job was to give effect to the common morality of society. He believed that the law's job was not simply to stop disruptive behaviors of people, but to suppress the vices of human beings. So what was this common morality in a society? He recognized that the common morality in a society was any conduct that, any widespread conduct of prohibition, intolerance, indignation, and disgust in that society. And he felt that this needed to be suppressed by legal coercion. He believed that the common morality of society is the morality held by an average man in society. Now, of course, this gives rise to a lot of criticism, especially writers like Ronald Dawkins criticize this idea and ask the question whether the average man's morality can be trusted and whether that should be the basis for lawmaking. Because he recognizes, or Dawkins recognizes, that the average man's opinion can often be not based on any kind of evidence, be irrational, prejudiced, gut reaction, etc. For example, there was a feeling or sentiment in society some time ago that homosexuality was a sickness. While this was lacking in any kind of evidence, completely irrational, this was an opinion that was held by average people in society. So should that be the basis for lawmaking? That is the question that needs to be asked if we are to follow this opinion that Lord Devlin suggests. But of course, Devlin believes that we must give effect to this common morality and individual freedoms may need to be surrendered in order to create a society which gives effect to these common moralities. The problem of giving effect to this common morality is that it may sideline the interests of some groups of people in society, especially minority groups. Professor H.L.A. Hart saw this and recognized this. He believes that the law's job is not to interfere with the private lives of individuals. He believes that what happens between consenting adults in the private realm should not be the concern of the law. Hart does, however, endorse the idea that there is one instance where the law needs to interfere even within the private realm, and that is where there is a potential for harm. Where there is a vulnerable group and there is potential for harm, the law needs to interfere even within the private realm. And that is why we have laws like laws protecting minors, laws protecting women, especially married women. We see laws pertaining to marital rape. We see laws pertaining to domestic abuse. Because although these activities are within the private realm, the law recognizes there is a vulnerable group and therefore there is a potential for harm. Therefore, the law must interfere. But Hart is of the opinion otherwise, where there is no such threat of harm, the law should take a step back and let people enjoy their individual freedoms. So individual freedom or common morality of society. Different people have different opinions, and some believe that individual freedoms need to be curtailed in lieu of the common morality or consciousness of that society, whereas others believe the law must take a step back and allow for these individual freedoms to thrive. Of course, this is not the only instance that this debate has come up. In fact, John Stuart Mills and Justice Stevens had this debate many years before Hart and Devlin did. And every so often, when society's opinions become more and more polarized, and as we see a divide between the majority opinion and the minority opinions, this question and this debate comes up. And we need to ask ourselves, what do we need to give effect to more? Individual freedom or common morality of that society? Now, this is an important question to consider, especially today, where the world is seeing more and more laws being passed which curtail the individual freedoms of human beings. So we need to ask ourselves, should the law give effect to this common morality of society and suppress our individual freedoms? Or should our individual freedoms prevail over the common morality of that society? Let me know what you guys think. Anyway, that's been it for this video. I hope you enjoyed watching it. Do consider subscribing if you like this kind of content. I'll see you again in another video just like this. Take care. Bye.